Welcome to today's Power Hour webinar brought to you by the North Carolina Bar Association Paralegal Division Utilization Committee. We are thrilled to have Justice Richard Dietz of the North Carolina Supreme Court. Justice Dietz comes to us with a wealth of experience in appellate law, including oral arguments before the United States Supreme Court. His legal acumen spans a vast array of areas such as constitutional law, complex business law, criminal law, family law, and tort law, representing clients from Fortune 500 companies to low-income families. Prior to his tenure on the court, he was a partner at Kilpatrick, Townsend, and Stockton LLP. We are privileged to have him share his insights with us today. Justice Dietz, thank you for joining us.
Well, hello, everyone. Thank you, Alicia. It's a pleasure to be here. I'm excited to talk to you all. I'm going to share some slides as I talk with you all, but just so you know up front, this talk is adapted from some presentations I gave when Alicia was on the board at NALA and asked if I would give some appellate talks at their annual meeting. And so I think it was more than 2.5 hours total of lectures that I had prepared. And so I took a lot of the slides from that, but I don't want to just give a talk to you all. I'm certainly not going to go for 2.5 hours, right? So my thought was I'd really like to have a conversation. So feel free at any point, I can see you're all muted, but feel free to unmute and ask questions or make comments if you want to. And also, if you prefer to just type in a question if you have one. And I'm happy to go in whatever direction you all would like to as we talk about appellate procedure and our state Supreme Court and the U.S. Supreme Court and all those sorts of things. So let me start. I'm going to share the screen, see if I get this right. Let me start off by just framing. I saw the title that you all got for in your invitation for this talk had the caption of one of the cases I argued in the U.S. Supreme Court called Abramski versus United States. So this is a courtroom sketch from Abramski, and I thought I'd start with this just to show you something funny about what happens a lot in appellate court. So in the U.S. Supreme Court, you may know there's no videos, you can't take pictures while the arguments are going on and things like that. So the courtroom sketches, as is the case with a lot of courts, are really the only visual documentation of what it was like in an oral argument. So like my wife in particular thinks this is hilarious because that is me, but that doesn't look anything like me. And although if you look at the 9 justices, I mean, they're very identifiable. Now, this was the 2013 term of the court, so a lot of these justices are no longer on the court, but you can see Ruth Bader Ginsburg there and Antonin Scalia and many of the current justices. And then this is another courtroom sketch, and which actually I think looks more like me, except that it looks, even now, I think like an old version of me. And I was only 37 when I was there. So, at the time, people thought this was hilarious that I looked like an old man. But to put it in perspective, I thought I would show you this courtroom sketch, which I just love. So this zombie looking person here sitting in court. Well, this is from Tom Brady, the very famous quarterback professional football player. When he was the New England Patriots, he had to appear in federal court in what was called Deflategate at the time, and this was a courtroom sketch in this federal trial court where you also couldn't have pictures or video of Tom Brady. And so in New England, more than anywhere else, they just thought this was hilarious. And I think this is boston.com where I found this one, sort of comparing, you all know what Tom Brady looks like. He's one of the best looking people in America, and then you look at this courtroom sketch and think, wow. But the thing about oral argument is that it tends to be the really sort of think of it as like what people think of as the sexy part of the appellate process. It's what gets all the attention. People listen to the audio. They go through, pick apart the justices' questions, and we're going to talk, I think, later about what's going on in those questioning and why it gets so much attention. But I wanted to start off by going through some of the other stuff that happens in an appeal, in particular because the main thing I want you all to get out of this talk is if you're on an appellate team right now, or you're like a lot of people, like a lot of lawyers really interested in appeals, and you're thinking, if one comes to my firm, I want to get involved and that sort of thing. There's some really key stuff that you can learn in just, half an hour of me going through this stuff here that can be game changing for you and for your appellate team. And so I want to talk about those things, and we'll sort of go through, that's why I called it Anatomy of an Appeal. I'm going to step through kind of the stages, what goes on, and the nuts and bolts of the appeal process and hit these really big picture points. And then at the end, I will talk a little bit. The Abramski case is an interesting because it's really a case where the issue is so simple, and it was just a question of statutory construction. And as is the case with all law, this is something you all know, but the law is just reasoning. It's not like quantum mechanics or medical doctors where you're dealing with this really complex stuff that only people with very specialized knowledge can understand. As you all know, when you talk to people that aren't in the legal profession, you're explaining that you realize, it's just reasoning, and I can explain to my spouse or whoever, and if you do a good job, they can understand the legal issues and things like that. And of course, that's what matters in winning your case, is being able to do that. And so I'll start with kind of the very beginning, because there's this huge malpractice trap. It's like the biggest mistake that gets made in the appellate process. And I made these little animated videos that I put on YouTube a few years ago with just like little practice tips and things about appeals. And so again, this is like a courtroom sketch. That's supposed to be me. I hired a contractor years ago to do this little animation that's on YouTube. And what's funny now is with AI, I could probably just give it a picture of myself and be a way better cartoon version of me. But one of these videos I did was about like this issue. And I think there's no better way than just showing you some of the little shots from this video. I just took a bunch of screenshots to walk through this key concept, which has to do with the filing process. So starting the appeal, which lawyers make mistakes here all the time. And you can absolutely save a case if you kind of understand this and avoid this mistake that gets made so often in the appellate process. So to set it up, though, I want to, you all probably have a sense of this, although you've maybe not thought about it with sort of this legal terminology, but I'm going to talk to you about deadlines and the sort of two key different types of deadlines that exist in the legal system. So the main deadlines when you're working on anything, in any kind of case that's before the courts, we just call them procedural deadlines, or sometimes courts will call them claims processing deadlines. But the idea is they're just things that move the case along. So, for example, when a complaint gets filed, starts a lawsuit, there's a rule of procedure that says within a certain amount of time, you have to file an answer, for example. Or if someone files a motion, you've got X amount of time before you have to file a response if you intend to file a response. Same thing with discovery. If one side says, produce all your documents about whatever, there will be a rule that says you've got this amount of time in order to do it. So the whole point is, if you didn't have those deadlines, litigation would take forever, because oftentimes people are busy, the clients, the lawyers, everybody. And so if you're not forced to kind of say, we've got to get it done by this time, it's going to take a lot more time. And then, of course, there can be strategic reasons why one side or the other wants the case to move more slowly. And so this is just for the efficient administration of justice. But the key idea is, as you all know, with these types of deadlines, if you miss the deadline for some reason, if you have a good excuse, typically, you can go to court and say, I missed the deadline, but I have an explanation, and everything will be fine. So, just to sort of conceptualize this, like imagine there's this lawyer who has some filing due at the courthouse, is walking to the courthouse to have it file stamped, because it's getting to the end of the day and it's due by 5 p.m. today, before close of business. And then this lawyer is not paying attention and falls in a hole and is, stuck down there for the rest of the day and isn't able to get to court and file it. So what happens? Well, you show up to court late and you say to the judge, look, I'm really sorry. I had the filing ready. I intended to file it on time. It was this completely unavoidable. There was manhole and there was no manhole cover, and I didn't notice. I fell in this hole. I was trapped down there, et cetera, et cetera. And, there's different legal standards for this. We'll call it sometimes good cause or excusable neglect, all sorts of different things. But the idea is just, you are saying, I've got an explanation. So please I missed the deadline, but sort of say no harm, no foul, and allow me to file this late or whatever. And in most cases, that's what will happen. So judges will say, okay, you've met the standard, don't do it again, or be more careful, that sort of thing. In the worst case scenario, there might be some kind of sanction, like if the other side had to do some things because of your late filing, there might be a sanction. So, there's a award of attorney's fees or something, but typically, you'll be allowed to make the filing. And the difference is there's another category of deadlines where that doesn't work, and these are called jurisdictional deadlines. And the idea here is, again, you all know this, but subject matter jurisdiction just means the power of the court to adjudicate the issue. And so the idea is that courts jurisdiction just is something that has to exist. So the court can't say, I'd really like to hear this issue, and so I'm going to find a way to say, I'll decide it, even if the court doesn't actually have jurisdiction, subject matter jurisdiction. And the easiest way to think about this is, think of all those very specialized courts like that are in places like Washington, D.C. So like the Court of International Trade, a federal court, is a good example. If you were someone in North Carolina, just imagine some woman from North Carolina who walks into the Court of International Trade, downtown D.C., and walks in and says, hi, I want to get a divorce from my husband. And, I filled out all the forms. Here's the paperwork. Hands it to the Court of International Trade and says, please enter my North Carolina divorce. That court is going to say, obviously we can't do that. Why? The technical reason is that court has no subject matter jurisdiction over a family law proceeding in North Carolina, and so just cannot do it. And nothing that the parties do or the judge can do can change that. So the court can't say, well, you've got a really good reason why you need to get a divorce, so we'll go ahead and enter a judgment for you. There's nothing that can be done if there's no jurisdiction. And so some deadlines in the legal system are called jurisdictional deadlines because the concept is you must take some action. You have to do something by a certain time in order to make the court where you're doing that have jurisdiction over whatever that is. Many of these are in the trial court, but as you can probably guess, this is where this is heading, is, if this was a jurisdiction, let's just imagine whatever this filing was, this lawyer is making in the previous example, is a jurisdictional deadline. You're the same exact scenario. You fell in the hole, you didn't make it in time. So you come in, you explain to the judge, I'm really sorry, I didn't make the filing on time. Please excuse me, I've got an amazing excuse, et cetera, et cetera. The court will just say, I'm sorry, I have to dismiss your case. I have no jurisdiction, and jurisdiction is not something that the court can fix. If the court doesn't have jurisdiction, it has no power to do anything other than say your case is dismissed. So the reason I'm telling you all this is the deadline to file a notice of appeal. So to start the process of appealing a case is one of these very rare deadlines. That's a jurisdictional deadline. And that means if you have a certain amount of time in civil cases, for example, it's typically 30 days to file a notice of appeal, and you don't file the notice of appeal because something, you've got the best excuse in the world, but you just didn't get it filed by that 30th day, then the court will dismiss your appeal, the appellate court, and say, I'm sorry, there's nothing we can do because we don't have jurisdiction. So I gave a CLE to lawyers one time where everything was internet memes, and this is one of my favorite ones. So the one when I was talking about this thing is I used like the shocked koala meme, and the reason is because I think, and you all have experienced this. There are a lot of lawyers out there that just miss deadlines all the time. In their community, they are well regarded with their within the bar. If something happens where they miss a deadline, they just pick up the phone, call the other lawyer, say, hey, can I file this one day late? And the other lawyer will say, sure, we'll just tell the judge it's no big deal. Or, perhaps if it's something where the parties can't agree, I'll just go to court and say, we've got a good reason. And you get these extensions all the time. And so these lawyers sort of miss deadlines somewhat routinely and then get shocked when they go to file an appeal in a very important case for a client and their appeal is dismissed. And, they're sort of now in malpractice territory because they, filed it one day late or that sort of thing. So what can you all do about it? I mean, one thing that I've noticed is that firms, and sometimes this is lawyers, sometimes it's paralegals, sometimes you may have other specialized staff if it's a larger firm that are doing this type of thing, but somebody is dealing with calendaring, right? And what typically happens is you put the deadline on the calendar for the day something's due, and you just do that over and over for everything that's coming in. So let's say the jurisdictional deadline to file this appeal is the 26th. What you should do to make sure this never happens is just put the deadline a week earlier. It's very rare that a client cannot decide until the very last day whether they're going to pay you to pursue the appeal, or if it's a case where there's a right to counsel, for example. Almost always in those types of cases, the client will say, yes, I want to appeal. So very early on there's going to be an appeal. And so there's no reason to wait until the last day, because that just greatly increases the chance that something comes up, some emergency, and no matter how good the explanation, you're in the hospital, whatever it is, you miss the deadline, the court has nothing they can do except say we don't have jurisdiction. We have to dismiss your appeal. So it's just a huge, huge malpractice trap that I see over and over. When I was at the Court of Appeals, before I came to the Supreme Court, that's the main court I'm going to talk about in a minute. You know, most appeals in our state are going to the Court of Appeals because there's an appeal by right. And you can see, you know, there's almost like one every calendar, roughly, where someone missed the deadline and the court's having to deal with that. So this is a great example of where if you're on an appellate team or you want to make the pitch, you know, your firm's going to be handling some appellate work and you'd like to get some exposure to that, you can say, hey, I can help you avoid some of the real traps here that happen to lawyers in these cases. And just remember, you know, remember these little cartoons, the idea of the jurisdictional deadline would just be the one that's taking charge of, we're going to make sure this notice of appeal is filed well ahead of that jurisdictional deadline so we don't get into any kind of problems with that. And anybody have any questions about this concept, the deadlines, the jurisdictional versus procedural, anything like that, before I move on to some other stuff? This is the big one. So if you remember one thing that I'm telling you, so you can say, like, I learned something from a talk about appellate practice, it's this, because it's such a common mistake. Anybody got anything? Okay, let me move on to like another area where I think you all can help within the appellate process. And this is about the record on appeal. You'll hear this term all the time when appellate lawyers are talking, and I want to explain what it means and kind of the idea of why there is a record on appeal and why it's so important. So, you know, the key concept is that appellate courts don't find facts. And so in order to review something, the appellate court needs to have some, what I call like a snapshot. They need to see a moment that's frozen in time where a trial court made the ruling that's the one that's being appealed, and to be able to see everything that was sort of the state of the litigation at that very moment in order to review and see whether or not it was an error. And typically things that happen afterwards, for example, aren't very relevant to the appeal, because the question that's being asked in an appeal is always, was there a reversible error that's made by a trial court? And so you need to know, well, what did the trial court know? What was before the trial court at the time? And then the other concept here, which I'll explain in a minute, is just that why it is that we don't find facts, which I've found really confuses especially the public. So one example of this I've always remembered is, so when I was on the Court of Appeals, this is the Court of Appeals building. Many of you may have seen this building. It's right in downtown Raleigh, across from the Capitol. And it's a really, I think, a really beautiful building. It used to be the Supreme Court building. And then the Supreme Court, they built a new building across the street that now houses the Supreme Court. And the Court of Appeals inherited what was once the Supreme Court building. And so when you see it now, it's sort of surrounded by skyscrapers right in downtown Raleigh, but it's a very old building from the early 1900s. So here's a picture of it back then. I just think it's funny to compare these two pictures and just remember a time when the Supreme Court building at the time was just surrounded by telephone poles and things, and that was about it. And but the inside of that courtroom is really also very beautiful at the Court of Appeals. So here's a picture of me from a few years back when I was standing in that courtroom. So one thing you can see if you look, you can see how this used to be the Supreme Court courtroom, because you can, if you look at the bench, you can see the almost like little divisions where there are, you can see in the front of the bench those little rectangles, and you can kind of imagine a chair behind each of those. And if you count, there's 7 of those across that bench. That was where the 7 justices of the Supreme Court would sit back when this was the Supreme Court courtroom. And but the other thing about it, it's not a particularly large courtroom. And as you know from the appellate process, the only seating that's available, other than the people that may be observers at the back of the courtroom, are for the lawyers who are going to step up to the podium and argue. And if you see a trial court courtroom, of course, there's a lot of other places for people to be sitting. You know, you're going to have clerks or deputy clerks. You're going to have a court reporter. Obviously, you're going to have a witness stand, all sorts of things. And there's none of that in this courtroom. And I always remember this because the elementary and middle schoolers will come to Raleigh for their school tours from all over the state. And a lot of times they'll ask if they can come and see a tour of a court, as in addition to, going to the legislature and other places. And I always enjoyed those because it's fun just sort of talking to the students and telling what we do and everything. And I'd always bring them into the courtroom because it's pretty impressive. It's a really beautiful courtroom. And occasionally, they would ask, as I'm sort of explaining what we do, things like, where does the jury sit, or, where do the witnesses go? And I'd have to explain, oh, we don't have a jury, we don't have witnesses, and that sort of thing. And the one thing that stuck with me is the one time someone said, well, what do you do then if you're not doing any of that? What does a court of appeals judge do? And I sort of showed them you could see through the door in this courtroom into the law library, and you could see all the volumes of the official reporter there lining the walls. And I said, well, if you've ever seen these books, these colored books that all have numbers on them, like in a lawyer's office, we just sit all day and we write opinions, which go in those books. And they said, well, what's an opinion? And I said to them, well, have any of you ever written a term paper before? And all these students were like, oh, that's so gross. Yes, I had to do a term paper. And I said, well, I write 2 term papers a week all year long, every year. And they had these horrified looks on their face. And I think one student even said something like, well, I don't want to be a court of appeals judge. And so, I hope I didn't convince people not to pursue legal careers with that little tour. But the point I want to make to you all about it is that there's a big picture concept there, though, in understanding why an appellate courtroom looks like that, which is that once you get to the appellate level, a lot of the reasons that you need all that other seating in a trial court courtroom no longer apply. So, why is there a witness stand? Why is there a jury box? Because one of the key things that's happening at the trial level is there's disputes of fact. So, was the traffic light red or was it green? And, you may have one witness who said, I saw that accident and I know the driver, the defendant, had a green light, no question about it. And then there may be another witness on the other side of the street that said, no, I could see plain as day, and it was a red light, and the defendant drove their car right through and T-boned this other car, and that sort of thing. And when you have a dispute like that, you have to have some way to have those people come and testify under oath, and then you have to have some mechanism to decide essentially who's telling the truth, decide what the actual fact is, because there's a dispute, and typically juries do that, or in some cases where there is no right to a jury trial or it's been waived, a judge will do that. And that's the principal thing that's happening at the trial court level, is resolving all those factual issues. And then once those facts are resolved, the court can apply those facts to the law, and that's how you get to a judgment. So when it comes to the appeal, then the facts are decided. And so, one example I often give is if you had some case where there was a car accident like that, and on one side of the street, there were 100 people that happened to be standing there. And these are like 100 of the most trustworthy people, like maybe it was some convention of the world's religious leaders or something. And they had all come out, and they were, they saw this accident, and they all saw that this driver had a red light. And then on the other side of the street, there was like one guy that stumbled out of a bar, and he was, sort of tipsy. And he comes in and testifies for the defendant. Oh no, it was a green light. I'm certain I could see it. The jury may listen to that testimony, and if they return a verdict and say, we think it was a green, for the defendant, and say we think the defendant had a green light and didn't run the red light, when it comes up on appeal, no matter how much we appellate judges may look and say, I do not know what that jury was thinking, if there's at least some evidence that would support that, we don't get involved at the appellate level. We don't get into those kinds of weighing of credibility and fact questions. That's all done at the trial level, and it's resolved. And the idea on appeal is we deal with legal errors. So where the court made some error of law. And so the important point is, in order for us to do that, though, we need to know everything that existed at the time the trial court made whatever ruling you say is a legal error. And that's the purpose of a record on appeal, is that you're just giving to the appellate court everything the court needs to know about what's the state of this case at this very moment. And when this happens, a lot of times lawyers don't take this step of the process very seriously. And this is another area where you can come in, because, I know a lot of paralegals. One thing I found is that you all tend to be much better, early adopters of technology, oftentimes, and also just generally more knowledgeable about what I would consider to be fairly simple things, but how to use technology to improve presentations and that sort of thing in a way that often many lawyers are not. And so you can step in here and help make avoid some mistakes. I'll show you one example here that sometimes lawyers do that I find inexplicable. So one of my former colleagues, Judge Stroud on the Court of Appeals, showed me this as an example one time so this is in a publicly filed record on appeal in a case that Judge Stroud and 2 other Court of Appeals judges were hearing, where the legal issue was about the boundary line between 2 properties and whether there was some one landowner had some property that was crossing over this property line, and this was the picture in the record on appeal of this disputed boundary line. And so as you can see, it's just a black piece of paper. It was some exhibit that was obviously introduced at the trial that was likely a color photograph where you could see this aerial photo. And then what happened is someone made a copy. It was a black and white copy, as many of you have probably seen. With a poor quality copy, you lose a lot of the resolution. And it may be that this isn't even the first, it's like a copy of a copy that gets scanned, because these days we electronically file everything in our state appellate courts. So you're converting it into a PDF. And at some point along the way, it became so blurry that this is a completely meaningless exhibit that's included in the record. And we can't engage in meaningful appellate review, the judges, if we don't really know what that snapshot looks like. What was the document that the judge was looking at here? Well, this is impossible to tell. So this is the sort of thing that you can catch and say, hey, we're just going to be converting all of these files into merging them into one giant PDF that we file that we call the record on appeal. So we have a really high resolution version of this photograph or whatever it is. Let me just go and take it and make it a PDF file, and I'll just insert this page in, and it is much higher quality than trying to make a photocopy and scanning it or whatever it is. There's lots of things you can do. It's also completely appropriate because you work with both sides in an appeal, work together to prepare this record. So you can coordinate with the folks on the other side and say, we need a better version of this, or perhaps like if it's a large plat map, the rules permit you to just submit a hard copy of. We've gotten those before, like in a tube, and we open it up and it's a giant map that we can look at. And it may be that that's a much better way to present that to an appellate court so they can see what it was that was going on in the trial court. And again, these are the kinds of things I think sometimes busy lawyers, who we're going to talk about in a minute, are focused on primarily the briefing and preparing for oral argument. They're just not committing the time to thinking about these sorts of things. Like, how do we make everything in the record as presentable as possible, strengthen our case. And so this is, and again, an area where you can step in, take a look at the record and say, hey, no one's going to know what this picture is. You need to improve it. The same thing is true with transcripts. This is from an excerpt from a Court of Appeals case, and where they are quoting a transcript, in this automobile case. And as you can see, as you're looking through this, I have no idea what this witness is actually saying. I mean, it's over and over again. Well, inaudible. And so she started and said, turn around, inaudible, turn around the car. I pulled up like a Walgreens and an inaudible, that he had an audible, but then an inaudible. And so again, this is meaningless. And this is another example where if you get the transcript back from a court reporter and you see this, the rules of procedure permit you to work with the other side and say, we know what this witness actually said. We're going to go and fill in the inaudibles. We can agree that we were all there and fix this. And it's worth putting in the time to try to fix something like this, so that when the court gets it, we can figure out what's going on. What could happen in a case like this, if we can't, is we just say we can't engage in meaningful appellate review. And the party that appealed the case ends up losing just because we're not able to understand the issues or understand the record. So the great example of somewhere where you can take control of this and really help your client. I wanted to talk a little bit about briefing. I see. Let me make sure. Okay. There's a question about transcripts. Yeah, so that's right. The question is, can you talk about providing transcripts? I understand they're not technically required, but they can be necessary. So so one thing to know that is correct, that in the rules of appellate procedure, there's an alternative to providing a transcript that's prepared by a court reporter. It's called the narrative, and it's actually a very, very old. You can find the concept of the narrative in the appellate record going way back in the Supreme Court case law. The idea is basically the two parties get together, and instead of having a court reporter who's transcribing the proceeding, they just agree to write out what happened. And if both parties agree that this is what happened, you can stipulate to what the facts are. And so you could just say to the court, this is what happened in this hearing. As you can imagine, that's a very time-intensive process compared to just paying a court reporter who's highly skilled to come in and transcribe it. And these days, this is somewhat controversial, but we're also moving to a place where you don't need a court reporter in many instances, especially if it's not considered an extremely important hearing. You'll just record it and have essentially AI transcribe it. And I think there's a lot of uncertainty there about where that's going to settle in terms of being acceptable to submit to appellate courts. But yes, there are alternatives to having the transcript that's prepared by a court reporter. But especially in an important case, the best practice is to have every hearing recorded. And then it is a somewhat complicated process because you need to then contract with that court reporter who is just there at the trial court because you've asked to prepare this transcript. You have to contract with them under the rules of appellate procedure to turn it into the format that's of a transcript that we require to review it at the appellate courts, and then handle the filing of that transcript. And over time, there's been a lot of confusion about that. I actually think that we have some rules changes in the works that are going to make it even clearer than it was in the past. But it's an area where, again, I think that the key point is you can take control of this process by taking a look at it before it gets filed, before we get a transcript as the appellate courts and aren't able to figure out what's going on. I want to talk a little bit about briefing also. This is an area where you all can help this is probably the single most important step in the appellate process because although oral argument gets all the attention, the briefing, the written briefing is really where every judge starts in reviewing the case, and it is the single most important, most persuasive part because that's where all the legal authority is, and it's what the judges and their law clerks spend hours and hours and hours going over before they get to oral argument, which is we'll talk about in a minute, is sort of about figuring out are the rhetorical tools the judges are going to use to try to understand what's going on in the case, or they may have genuine questions and they're going to ask them, but the briefing is when they kind of understand the case and the legal issues. So I call the sort of the format that's the winning way to write briefs classic style. It just means a conversation with the reader. And going back to what I said earlier, the idea is just you should be able to read a brief that some lawyer on your team prepared. And if you read it and you don't know what's going on, it's probably not a good brief. And I think it's absolutely appropriate for you to look it over and say, hey, I'm a little confused about what's going on in this section, because if you can't figure it out, chances are the appellate judges, who are also just generalists, they haven't spent all of this time getting into the weeds of this issue. They too may say, you lost me here. So like one example, I just picked a case from when I was on the Court of Appeals where I had to do, I do introductions in my opinions, and it's like a little elevator pitch of what the case is about. And the idea is, could you read this just knowing nothing about the case and then have a good idea about what's going on? And so, Dave Rieger got pulled over for following too closely. Law enforcement found marijuana and marijuana paraphernalia in Rieger's car, arrested him on 2 charges, possession of marijuana paraphernalia. Rieger took his case to trial, and the jury convicted him of both charges. To Rieger, this all seemed like one criminal case against him, but the state filed the 2 charges against him in 2 separate charging documents, and the trial court entered 2 separate judgments. In each of those judgments, the court assessed court costs, amounting to a total of nearly $800. This appeal is about those court costs. The statute authorizes court costs in every criminal case in which the defendant is convicted. So the question is this: what Rieger experienced, 1 criminal case or 2? And having read that, you don't need to, if you're an expert in these criminal cases, you do them a lot, you may understand kind of the concepts of what exactly is a charging document, the different ways, all that sort of stuff. But you really don't need any of that to understand what the case is really about, which is Rieger got charged with these 2 crimes, and he certainly, it felt like one case because he went to a trial, he got convicted. Then the state was saying, actually, technically it was 2 cases because we did it all as 2 separate ones. And the question was, when the legislature said in every criminal case, you get court costs, what does it mean? Does it mean what Rieger thought it meant or what the state thinks it means? And that's good classic style. It's just being able to look at it. And so one thing I want to contrast that with, because some lawyers do this, and this is somewhere you can point this out, and because this is good writing, it's just not good legal writing, is to use a lot of like rhetoric and literary flourishes. The example I like to use is Moby Dick, because we all had to read, this Herman Melville's masterpiece at some point in school or whatever, and it is a monumental work of literature, but there's some things. So this is just from the very beginning. This is when Ishmael's deciding he's got to go back out to the sea is calling him back, right? And there's this explanation of like what happens when he kind of gets this thing where he goes back out to sea, and it says, whenever I find myself growing grim about the mouth, whenever it is a damp, grisly November in my soul, that. And so the thing I point out is that's to me, that's beautiful. And it does conjure in your mind this idea of like what's going on with him. But nobody actually talks like this. And in a legal case, you're typically stuck with the facts as they're described in the case. And because no one talks like this, no one's going to get up on the witness stand and ask, what was the defendant's demeanor at the time? No one's going to say, it was a dark, drizzly November in their soul. They're just going to say, well, the defendant looked really depressed or something like that. And so that literary flourish, although it may work, in something like Moby Dick, it just doesn't belong in your brief. Because if people don't talk like that, putting that into your brief is just a distraction, and it will often frustrate judges. You say, tell me what happened at the trial. That's all that matters. Because again, we're not finding facts. So your rhetoric about trying to spin it is not as important as us knowing what are the exact things in the record that happened, so we can apply the law there. And a lot of lawyers just have trouble with that because they're very passionate about the case. And so you can, I think, look at it and help walk back and say, is this rhetoric really needed here? Or is there some better way to describe it and that sort of thing? Another thing to talk about really quickly, this is something that years ago I kind of really pushed this, and now I think it's accepted. But the problem is there's still a lot of lawyers out there that have been practicing for a very long time that do not know about this. And again, you all tend to be the types of people who get how simple this is, and you can explain it to a lawyer that does not understand. So I'm gonna tell you all about it and something to watch out for. So there are so many different types of fonts, as you know, and ranging from ones that I find just to be very elegant fonts that you see in novels and magazines and things like that, to like the really wacky ones like Wingdings and all that stuff. And here are a bunch of examples that from another one of these little cartoons I did. So a font that you see all the time, especially in older legal writing, is called Courier New. And Courier was a font that was designed, it's well over half a decade now, for a bunch of different reasons. IBM, for example, used it early on in computer coding. It was used with a lot of things like typewriters. It is a font, it's called a monospaced font because the space between every letter is the same, no matter the size of the letter. So just to think about it, imagine like you're typing on a typewriter. So here's a word you just typed, which is a typo. So every single one of these letters is taking up the same amount of space. And that means, if you're on a typewriter, that you can take that word with the typo and you can just remove the letter that was the wrong one and insert the right one. Now you'll notice a W takes up a lot more space if you think about it, just the size of the letter W than like the letter I would. And so what a monospaced font does is the amount of space that the letter I takes up is the same as the letter W. And that wastes a lot of space. So there's another type of font, they're called proportional fonts. So the one that we use at the Court of Appeals and the Supreme Court is called Century Schoolbook, but there's a lot of others. Times New Roman, which is probably the best known, it's a default font in a lot of word processing applications. It is also a proportional font. If you notice, just looking at this, the amount of space that the I takes up is not the same as the W. That's why it's called a proportional font. And so why use these proportional fonts? Well, because it makes things much easier to read. So one of the problems is if you use what's called full justification, which is how the formatting is in our state appellate courts, That's where, if you recall, so the margins on both sides are even when you have full justification. And as opposed to, left justification, you also often see where the left side is the solid line, but the right side, if a word is too long to fit it, it just gets kicked down to the next line. But if you do full justification in particular with a monospace font, you can get really wacky stuff because what's happening is your word processing application is automatically trying to make it work, and it will start adding in extra space not only between the letters, but also in between the words, because it can only do so much with the letters. Whereas in a proportional font, it can make these changes automatically and make it work in a way that's doesn't create these rivers of white space that can flow on the page. Another thing is, this is why we used 2 spaces after a period, because back when we were using typewriters and everything, and it was all monospaced fonts, you needed that extra space after a period to help your eye see that there was actually the end of one sentence and the beginning of the next, because otherwise that amount of space there is so uniform that it can make it difficult. And as you can see, just comparing those 2 sentences, even with just 1 space in a proportional font, it's very easy to see where one sentence ends and the next begins. So the whole point of this is just to say the proportional fonts are just a much more elegant, easier to read fonts. And they're basically required now in every appellate court that I'm aware of. So you cannot file a document in a monospaced font like Courier New. It's a rules violation. So in North Carolina, we're flexible. We recommend Century Schoolbook, which is what we use, but you can use another proportional font. And there's even some examples listed in the rules. But some courts actually specify you must use this font. But I think I'm not even aware of any appellate court anymore that still says, yeah, use Courier New. But a lot of the old go-bys and things that lawyers use when they're preparing an appeal still use Courier New, because it's what everyone used in the 80s and the early 90s and things like that. And so if you see that, you should point it out, because not only is it just bad brief writing, but it's a rules violation in North Carolina. And a lot of lawyers just don't know that, because it's buried in some rules and some instructions in the appendix to the rules of appellate procedure. And if you're not an expert who's reading those rules all the time, you just may not catch that in your filing, and you think you're looking at some go-by that was approved by the court before and just have no idea that you can't do it. So, and again, everything I just explained to you is a great, if someone's saying, I don't know, briefs always look like this, you can point out the rule to them, but you can also just explain it. That doesn't even matter. It's just good appellate practice to use these fonts that are the ones that are easier to read. Okay, I do want to talk quickly about oral argument. And again, if you have questions about this, people are kind of thinking about this because the U.S. Supreme Court has had some high-profile cases recently. Most recently, they heard the arguments about the presidential immunity question for former President Trump, and they asked a lot of questions. I'm going to quickly tell you what's going on with those questions. Sometimes in a trial court, the judge is asking questions because the judge is busy, has a huge docket full of cases, and honestly needs to know, okay, help me understand what's going on in this case again. Remind me what the claim is. What is the evidence, that sort of thing. That's rarely happening at the appellate courts. Appellate courts are using oral argument. The judges are testing the legal arguments made by the parties, and often doing it in a way that's making sort of their points about what they think the law should be for their colleagues, because after the argument, the judges all go back into a conference room and vote about how the case is going to be decided. And the oral argument can be an opportunity to have the litigants, their lawyers, make the strongest arguments available. And so that you can go back and say, well, you heard when I asked the question, that sort of thing. So one easy way to think about this, I have this hypo that involves this contract to mow a lawn. So the contract says, mow my lawn back and forth in straight lines. And so, you sign a contract, you agree, I'll pay you $100, whatever. So the person comes and mows the lawn diagonally. So now the question is, well, is this back and forth in straight lines or not? Is it back and forth in diagonal lines or something? And so, you got these judges, it's gone all the way up to the appellate court. What are they doing when they're sort of asking questions? Oftentimes they're doing things like hypotheticals to understand what's the implication of what we're saying. So for example, they may ask a question that says, well, what if you went back and forth in straight lines, but they were like a zigzag lines? And, the challenge, the reason that you're testing the parties' arguments with this sort of question is you can see that one side is going to say, look, the contract says what it says, back and forth in straight lines. That's back and forth in straight lines. And, the other party is going to say, everyone knows when you say back and forth in straight lines, that there needs to be, some consistency. You can't just do some crazy zigzag pattern. And, you can imagine stretching the hypothetical. So the judge is saying, well, what about if it's a maze-like pattern? Are you really saying that this is back and forth in straight lines, even if that is in fact the way that, the mower physically was moving when it made this crazy design in the front of someone's yard? And, but the whole point of these questions, like I said, is just the judges are saying, whatever we do, because we're appellate judges, will create precedent. This will become the law. So we need to know whether our holding is, not just in this case, but in other cases that may come up, what it will mean. And so like I can give you a concrete example of this happening because I listened to some of the Supreme Court of the United States when they just heard the argument about presidential immunity. And, so one of the arguments from Donald Trump's lawyer was if it was an official act as president of the United States, there should be immunity. And, can't be, even if someone thinks it was a crime, you can't be charged. You have absolute immunity from, being hauled into court to answer for that conduct. And so one of the questions the justice asked was, well, suppose the president instructed the army to initiate a coup and take over the country. Are you really saying that if the army then did that, that you couldn't charge this former president with some crime after, the president is overthrown for, trying to initiate a coup? And so why ask a question like that? Because that's obviously not what happened. And it is because the justices are trying to figure out where would the line be if we're saying there's some sort of immunity for all presidential conduct and sort of official conduct as president. And that's what's going on in these arguments. So the justices are not confused when they're asking these questions. They're trying to test, we'll have to make some legal holding. We know what it might mean in this case, but what in other scenarios, what might it mean, and trying to understand. And then of course they're making these as rhetorical points also, so they can go back in the conference, like I said, and say, well, you heard the answer, and that, that can't be the law. So we've got to find some other solution. That is the end of my presentation. I thought if there's any, if anybody has any specific questions, I thought I'm happy to answer them. And otherwise, I was going to just quickly, because Alicia had put in the title of this talk that I would mention Abramski, so I was going to just explain to you quickly a little bit about Abramski and some of those other cases I've handled and what what you can learn from them. But first, is anyone thinking about appeals or is on an appellate team now? I'm just curious if you have any questions. I mean, now's your chance to kind of ask someone that's on the Supreme Court and has to deal with this all the time. So anything before I turn into like grandpa telling you war stories?
Hi, I actually do have a question. I'm already on an appellate team, and I just wanted to know if you could talk a little bit about the best way to help your attorney as a paralegal prepare for oral arguments.
Sure. Yeah. So one thing that in important appeals that typically happens is we would call it mooting the case. So for example, in the Abramski case, I mooted that I think 4 times. That was a very important case for me that I spent a lot of time on. So I went out to Northwestern University in Chicago and to their law school, to a bunch of appellate experts that have volunteered to sort of be the justices, and it's essentially like a mock trial. It's to sort of stage it and ask the questions that they think the justice might ask. And then I did one at the Georgetown Law Center, which has like an actual replica of the interior of the U.S. Supreme Court at their law school. And then I did one with the members of my firm, and then I did one with some volunteers from Wake Forest Law School. And that was a lot of work. So in sort of the mine run appeal, you're never going to have the capacity to do something like that. But what you can do is kind of replicate some of that moot court process by just figuring out what are likely to be some of the tough questions, and let's make sure we're thinking about it ahead of time. So for example, when I was saying before, if it's a good brief, you can read it and understand exactly what's going on. And that means also, if there are weaknesses, being able to point them out. So probably the most important thing to do is just take a minute, sit down with, the other folks on the team and say, here's some questions that I have, if we get this question, what's going to be our answer, that sort of thing. That can be one of the most valuable parts of the process, because that way thinking on your feet is an important skill for lawyers that do appellate argument, but because you just never know what, wacky hypothetical. I've heard Sonia Sotomayor, for example, she can ask some really tough hypotheticals, and it's really hard to prepare for those. But if you spend some time thinking about it, it can really help you give the answer that kind of knocks it out of the park. So that's one thing that I would suggest. The other thing is there's a lot about the process of getting ready for oral argument that can be very stressful, and you can help kind of take over some of those things. So, of course, during the pandemic, we did some remote oral arguments at our state appellate courts, but we're back to, I think in almost every case, it's in-person argument. So you're going to be traveling to Raleigh. There's a lot that, you've got to make sure that you got with you for an argument, everything, the record, any exhibits or anything that you're using, all that sort of stuff. And yeah, I remember I was doing that when I was a young lawyer for my mentor, who's a very well-known appellate lawyer. He has argued a lot in the Supreme Court. He had clerked for Justice Anthony Kennedy, who was a former Supreme Court justice. And yeah, I spent a lot of time in getting ready for the arguments, just making sure that everything that we could possibly need we had with us, and in case you get some question at the argument from a justice, or judge saying, what about this, what about that, you can be the one that knows the record is there. And so the lawyer can step away from the podium, say, let me just find this for you. Or it may be, when I get back up on rebuttal, I'll have an answer for you, and know that it's there. And, you're not going to have to do what's sometimes awkward in these cases, which is say to the justice, I'm really sorry, I don't know the answer to that question. Yeah, I hope that helps. Anything else anybody has about the process or anything like that?
I have a question. What percentage of the time is technology actually used in presenting the evidence used during appeal? And also, what is the most preferred technology used?
Yeah, it's still pretty rare. And I'd say that the most useful form. So in the Court of Appeals in particular, they've I should have said this earlier, but the vast majority of cases are going to the Court of Appeals and stopping there. So the Supreme Court, we decide about 70 to 80 cases a year. The Court of Appeals is getting anywhere from 1,500 to 2,000 that they're deciding. So, most cases, and that's because you have a right to appeal in most cases to the Court of Appeals. And then it's what's called discretionary review. So at the Supreme Court, we're picking and choosing just the most important cases. We don't have to hear the appeal when the parties ask us to hear it. And so the Court of Appeals has some really useful technology that's right there. So on the bench, they have monitors. They have, like an Elmo that's there for the parties. So if you have a document that's in paper form, you can just set it on there, and it's displayed on the screens for the justices, as well as on a big screen that's in the courtroom. There's also the ability to have presentations and things that you can have preloaded that you can walk through. The most useful applications for that kind of technology, I think, in the appellate arguments are when you're dealing with specific language text. So for example, if you're having a dispute over a contract, the exact language of the contract that's in dispute, that can be helpful to just put that on a screen. So as you're arguing, the judges are looking at this disputed language as you're saying, this is what it means. And the same thing is true with statutes. So when you have some question about, some written law or a regulatory question, where the most important thing is to see, what does this law say? You can put that up on the screen. I've seen some attorneys that have experimented with other sort of applications, the sorts of things you see a lot in complex trial litigation. So these days it's really easy to make videos that sort of simulate things, and you don't see a lot of that because since it's just legal argument, if you're going to show something like that to the judges, you would have had to already have presented it in the trial court, and then typically the question on appeal is going to be something like, was it admissible or not? And because the persuasiveness of those sort of that sort of documentary evidence is, again, for the jury or for the trial court, and it's not a question typically on appeal.
Thank you.
Anything else, Alicia? It looks like we're almost out of time, so I'm happy to close it out here unless anyone has any other questions.
Okay. Did you already cover the Abramski matter. I wasn't sure if you completed that.
Yeah, I don't think you all want me to go into storytelling mode. I can tell you one joke about this, though, it's always stuck with me. I lost the Abramski case. I lost it 5-4. It was a case about gun owner rights. It wasn't a huge surprise based on the questioning at the argument. It is the most painful way to lose to a 5-4, at the Supreme Court here in North Carolina, where there's only 7 of us. It would be like losing a 4-3, because you're always wondering, why couldn't I get that one vote? And when I argued Abramski, it was the swing justice was Anthony Kennedy, and I just couldn't. He did not vote with me, and so I lost the case. And but the joke I'll tell you is the reason that's such a painful way to lose. I've always remembered the story I heard about Chief Justice John Roberts, so the current Chief Justice of the Supreme Court, who is one of the most skilled appellate attorneys ever in U.S. history. He's just an incredibly talented appellate lawyer before he became judge and later Chief Justice. And I heard a story that one time at his firm in D.C., he argued a case and he lost. It came back and it was a 9-0 decision that he lost. And I guess some of his partners said to him, "Wow, why do you think you lost 9-0?" And he said, "Well, because there's only 9 justices on the court." The joke being like he knew, and it probably prepared his client for the fact that he would make the best argument they had, but he knew the justices and knew he wasn't going to win, even going into it. And so, so there's your little story about John Roberts that you can pass on to people.
Thank you, Justice Dietz, for that presentation and for sharing your expertise with us on Law Day. I don't know if anybody knew this, but I heard it's Law Day today. We greatly appreciate the time you've taken to engage with us today. And so to our attendees, thank you for joining us. Thank you for your questions and your participation. We hope you found the session valuable, and we look forward to seeing you at future Power Hours. So I hope you have a wonderful day. Thank you again.